Spouses make agreements with each other all the time. But when are these agreements enforceable? Is it only if they're in writing? The 1997 California case of Estate of Sheldon examines these questions in the context of a husband who lost his wife less than a year after marrying her. Florence married Al Sheldon in 1974, about 8 months before she died. She did have a will that she executed prior to her marriage to Al. It was a valid holographic will that provided for her estate to be distributed equally between Marion and Helen, Florence's children from a previous marriage. Al, who wasn't mentioned in the will, assigned his interest in Florence's estate to Helen and her husband. Marion petitioned the trial court for a determination of heirship regarding Florence's estate, and Helen and her husband filed a claim for their share as well as Al's share assigned to them. Marion alleged that Florence and Al had an oral prenuptial agreement in which they both agreed to waive claims in the other's estate. The trial court determined there was a prenuptial agreement and that upon her marriage to Al, Florence changed her position to her detriment in reliance upon their oral agreement. The court further held that Helen and her husband were estopped from invoking the statute of frauds, since the contract had already been fully performed. Helen and her husband appealed.